Welcome, everybody. We are really thrilled to be here this morning with Meredith Grigg from the Northwest Justice Project, who's put together a presentation about planning ahead and just giving us sort of a broad stroke view of things that we want to have in place, legal documents, medical documents, so that we can just have a smoother sailing in life if we face the unexpected, which we definitely seem to be facing the unexpected quite often in this world. So I'm going to hand it over to Meredith, and so glad to see you all here today.
Great, thank you, Tracy. And I forgot to ask, and we probably covered this before, but what time do you want me to stop? I didn't know if you had other items on your agenda for today.
Yeah, we have it slated as a 9 to 10 slot, so
okay. Just go on.
If the questions exceed that, then by all means, if you have time, let's go ahead and we can push past 10, no problem.
Okay.
And any of you out there, my wonderful viewers, if you need to leave beforehand, that's fine, and we are recording. So.
Great. Okay. I'm gonna share my screen for you all because I'm a visual person, and we're talking about a lot of different things today. But anyway, I'm Meredith. I'm an attorney at the Northwest Justice Project, and I'm in the Seattle office, so we don't have snow anymore. So it's exciting to hear about the weather you all are experiencing. But I'm so glad to be here today. I've been an attorney with the Northwest Justice Project for about 15 years now. Oh gosh, yes, 15. Yeah, my oldest child is 16 years old, and I started when he was 1. So that's how I keep track of how long I've been at the Northwest Justice Project. But the Northwest Justice Project has a contract with our local area agency on aging to provide legal services to low-income people and low-income seniors in the King County area. So my work is primarily working with seniors and doing a variety of things, including a lot of things we're going to talk about today. And Tracy and I talked about it. I'm covering a lot of ground, and if you have questions, please just feel free to interrupt. Tracy's going to keep track of the.
Feel free to interrupt. That never works well.
Tracy's going to keep track of the chat box to see if there are any questions, and she can interrupt me as well. Was there a question, or was that a open mic, a hot mic?
That was a hot mic. I'm starting a muting job.
Yeah, I've done it myself, and I've been on the other end of that. So anyway, here's my little roadmap of what I plan to cover today, just so you have an idea of where we're headed. And it's, as you can see, kind of a windy road towards planning ahead for the future, which none of us has a crystal ball, or I don't. We're doing our best just to plan ahead and take care of hopefully the unexpected as we move forward. But I'll be talking about what I'm calling, what a lot of people call decision support. So things like powers of attorney and other documents that can help you appoint people to make decisions if you need help. And I'm saying you might be the person who wants these documents, or you might be helping somebody. I just say you generally. Long-term care, we're going to talk about. I'll touch on wills and trusts and probate. So let's go ahead and get started. And I wanted to just talk briefly about sort of the first question that I usually ask clients. So I get clients who call in or come in and say, you know, my mom is having some trouble managing her healthcare, her finances, and she needs a power of attorney, or she needs a guardianship. No matter what, the first question I always ask is about capacity. And what that means is the ability to understand legal documents and the implications of your actions. That's sort of the legal definition of what we mean by capacity, but it's generally the first question I ask because it will affect the advice I give and the kinds of tools that are out there to help people who need help with decision making for finances, healthcare, and other items. So when we talk about decision support, I'm going to be talking about these different tools that can be used for that purpose. And some of these you may have heard of, some of them you haven't. So, commonly durable power of attorney forms, healthcare directives, the PULSE form, and then we'll talk a bit about what tools are available if the person who needs help no longer has the capacity to sign legal documents. And that includes representative payees, consent to healthcare statute, and guardianship. So again, we go back to the first question I ask is, does the person have capacity? If the answer is yes, we're looking at things like powers of attorney, healthcare directives, honestly, a whole lot easier than if the answer to the question is no. And I'll cover those tools in just a bit. But let's start with mom has capacity, so she can sign a power of attorney document. And this is a document that allows you to appoint a trusted person to make decisions for you. So we call the person signing the document the principal, and the person who makes the decision, the trusted person, the agent. And here's an example of a do-it-yourself power of attorney form we have on our website or on the Washington Law Help website that Northwest Justice Project manages. And at the end of the presentation, I'll show you where you can find these because they're available online to print and fill out and take to a notary.
Let's see.
Does someone have a question? Okay. So the power of attorney for finances allows the agent to make decisions, financial decisions. So we have on our form and most forms, you should appoint an agent, you should appoint an alternate. And that's it's a great idea to have an alternate person just in case the first person's unavailable. The thing I always say about these durable power of attorney documents, just to clarify, is that if you sign a document like this, you always retain the right to make your own decisions. This is really, it's a good analogy that I heard once was signing a power of attorney document is like giving someone the extra keys to your house. So, we've all had that situation where you show up and you've forgotten your keys. And so it's nice if you can give a copy of your key to your neighbor or somebody else who can then come help you out if you need it, but it's your house. You have the key, they're just there to help you. I recommend durable power of attorney forms because by durable, it means that this form remains in effect. Your agent can keep making decisions for you, even if you become incapacitated or unable to voice your preferences. And then the other just note to point out about the power of attorney forms is you can decide whether you want your power of attorney form to start today when you sign it, or if you want it to be what we call springing, that it would spring to life later at some other event. Usually that event in power of attorney forms is if your doctor says you no longer have capacity to make decisions for yourself. It's a little, there's debate about what's the best method here. In my opinion, I say just make it effective immediately. The difficulty with springing powers of attorney is that then your agent or potential agent has to go to your doctor to get a notice or a letter saying you don't have capacity. It's just another step that your agent would have to take. I understand why some people want that for later. They don't want the potential that their agent could start making decisions that they don't like. But always keep in mind too that these forms are revocable at any time. So I should just back up for a moment to say these forms I always say should be completed by anyone over 18. I think that everyone should have a power of attorney form because life is so unpredictable. And I have my friends and I got together at one time and we all did our power of attorney forms and notarized them. So I highly recommend, just in the instance where you need some help and you're not able to speak for yourself. So that's a power of attorney for finances form. And then this is an example of a power of attorney for healthcare. And you can see we've got two separate forms. Sometimes you'll see power of attorney forms that are for both finances and healthcare all in one, which is fine. I prefer separately because you might have somebody who you'd like to manage your finances, but you want a different person to manage your healthcare. So having two separate documents allows you to appoint different people. The other thought with keeping them separate is the importance of these forms is that the medical provider or bank representative or whomever your agent takes the form to, you want them to be able to use it. And you want it to be easy for the bank representative to look over and say, oh, yes, you have the power to do this, or medical provider. With a big form that has both healthcare and finances, it can just, it kind of creates a situation where you have a bank representative looking through healthcare information or HIPAA language and vice versa. So just my random thoughts about why to do them separately. Again, just want to point out, you always keep your own right to make your decisions for yourself as long as you're capable of doing so. And, you know, these forms can be revoked at any time. And I just want to point out real quickly, in case it comes up for y'all, again, I'll show you where to find the forms, but we also have power of attorney forms translated into other languages. So if you know somebody or you're working with somebody who speaks another language, we do have them translated into other languages. So it'll have the English and the non-English language in the form. And then really important, the power of attorney form needs to be notarized. Best practices to get your power of attorney forms notarized. Understand that there are times where you really can't find somebody, you can't find a notary. These can be witnessed by two people. I think, you know, if I had to say preference-wise, financial power of attorney, if you can get it notarized at all, absolutely do that, just because there are a lot of national banks that require that. Healthcare power of attorney, less urgent to get it notarized. You can have it witnessed. I certainly have talked to medical providers who have somebody in the hospital where they can't get a notary, but they do need to appoint a decision maker. And so in that situation, having a couple of witnesses works as well. And then where do you put these documents once you've completed them? So best practices, give the original to your agent so they have it and they can go use it. And you can give a copy to your alternate and then keep a copy in your important papers. You can also just keep, so I have a firebox in my closet, and I've just told my alternate agent where my power of attorney forms are. So that's an option too, but just make sure your agent knows where to find it. Also folks upload these documents to Google Drive or the cloud someplace. So you can upload them, that works fine too. It does make it easy to just transmit to other people if needed. But yeah, they don't have to be, it used to be you would record power of attorney documents. That was pretty common with the county. Not so much anymore. The documents that are recorded are public documents, so you may or may not want your power of attorney available to the public. In addition, if you decide to revoke your power of attorney, you then have to also record the notice that your power of attorney has been revoked. So it just complicates things. There are some property transactions where you would have to record a power of attorney document, but honestly, keeping in a really safe spot, making sure your agent knows where it is the best way to go. And I'm going to move on to healthcare directive, but does anybody have any questions about powers of attorney? Hopefully I'm being as clear as possible.
Are there any qualities? Are there any qualities that you should like think about or look for in a person when you're naming them as your power of attorney?
Yeah. Oh, that's a good question. So one thing is to think about age. I used to work with an attorney who did a lot of estate planning, and she always said, go a generation down. So the reason is I've certainly seen people who appointed their friends, which is what I've done, but then as they aged, their friends began passing and they didn't have an agent anymore. So if you can go a generation down, even if your alternate agent is a generation down, that's a great thing. That's just an age situation. Then, we use the term trusted person. Really, this is somebody who will be making decisions for you. For instance, if you're in the hospital and not conscious, you just want it to be somebody who you trust. Somebody who's going to keep a level head, somebody who doesn't have beef with like the rest of your family or whatever, which may be hard to find, but that's where you kind of see the problems with these documents, and where people end up in court is where there's a lot of acrimony between different people who support and care about you. So those are just some things to think about, but that's a great question. I'm sure people have other examples of good qualities to look for when they're selecting their agent in a power of attorney form.
And just one other thing, would it be a good idea just to tell your whole family who you've chosen, once you choose that person, and just say, hey, this is what I chose, and, and I'm in communication about what my wishes would be. And
yes, I think in a perfect world, yes, you would tell your whole family, this person is my agent. If you believe that you're going to offend somebody, there's no requirement that you tell. So it shouldn't be controversial, but I understand families are real. And so you're not required to tell your family, anything about your legal documents. But it would be nice if they knew, okay. And I know my, for instance, my dad has already said to me, okay, hey, your brother is our agent in the power of attorney form. I'm like, great, good. Then if things are difficult or decisions need to be made for my parents, I know my brother's on top of it and he's going to be handling, and that's who I should go to. So that's helpful. But yeah, family dynamics are fun. So I'm going to move on to healthcare directives. So this is, we used to call these living wills, and people still do, and there are a lot of versions of this kind of document out there, but it is traditionally a document that says what you want to happen if you can't speak for yourself and you're terminally ill, or you are in a permanent unconscious condition. And it talks about what kinds of treatments you do or do not want to have in that situation. And so things like CPR, artificial hydration, nutrition, and these are really the treatments that we listed here are just treatments, or are mostly treatments meant to keep someone alive artificially. They can't breathe for themselves, for instance, or eat for themselves, their heart has stopped. That's sort of your traditional living will or healthcare directive. You get to say what you want to happen in those situations. We've certainly added information about like comfort care medication in those situations to relieve discomfort. The other piece that we've added to this form that I want to point out, and that we're developing even more, is a place for folks to list out what we're calling their healthcare values. And that's in any situation. Again, in a situation where you can't speak for yourself, these are things that are important to you. It doesn't just have to be if you're terminally ill or permanently unconscious. And we've thought about healthcare values in these kind of different quadrants as we're thinking through, again, how to develop the form so they're the most helpful possible. But allowing people to really say how they want to be treated or cared for if they can't speak for themselves is something we'd really like folks to be able to do. It's great if you can have a conversation with your family or your caregivers or friends who will be there, who will be making decisions for you or helping with your care. But it's also really great to be able to lay it out and also think about what's important to you. So as you can see here, we have different examples of things people have listed in their healthcare directives. So things like what makes life worth living for you, and that's a different answer for every single person. So what are things that you enjoy doing that if you couldn't do, would really impact your quality of life? Things like your hopes, the things that you want to be part of your care and be part of your end of life care. So I've had people be sort of general and then people be very specific, like I want my blue blanket and I want to listen to this kind of music and eat this kind of food. Or the other important thing that I've seen listed in these healthcare directives are religious values and traditions that they want to be honored and implemented when they're receiving care or at end of life care. So, and then also talking about things that folks are afraid of with regard to their bodies and their medical care, as well as where they would like to receive care. So that's something we're really trying to encourage folks to have those conversations with families and to write it down so that in a situation where you can't speak for yourself, someone will know what's important to you. And then again, healthcare directives should be notarized. Best practices, get that healthcare directive notarized if you can. If that's just not possible, you can't find a notary, then having a couple of people witness it. I've listed on the slides. Oh, and I should say too, Tracy may have already shared this, but this presentation is available to you all. I think Tracy will send it out after the presentation so that you can hang on to it. But just so you know, there are certain people who can't be witnesses for a power of attorney and healthcare directive. They're actually different, and I listed the ones on the power of attorney slide. But so for instance, in a healthcare directive situation, somebody who's related to you by blood or marriage cannot be your witness on your healthcare directive, as well as if they're entitled to inherit from you, or if they're a physician or employee of a healthcare facility. That's just to protect you from greedy relatives, I think. So, and then again, where does this document go? Similar to your power of attorney form, if you have an agent for healthcare, if you've done your power of attorney for healthcare and you have your own agent, you want them to not only have the power of attorney form, but this healthcare directive so they know how to direct your care. Also, if you have an alternate agent, again, and put it in your important papers. If you don't give it to your agent, make sure your agent knows where to find it. And then also see if your medical provider will add it to your file. So I certainly have, so to back up just a moment, these documents are so interesting because they're legal documents, but they're also contain a lot of medical information and are used by medical providers, especially your healthcare directive and your healthcare power of attorney. And I always have this, like I'm a lawyer. I wasn't trained in, the details of what, a feeding tube looks like and what these different treatments are. And so I always encourage folks as they're making out these documents, if they can have a conversation with their medical provider to get some more information about what the treatments entail, what they recommend. So that's another person I would recommend having a conversation with about healthcare decision-making for the future. But there are hospital systems that have a database of healthcare directives. And so just inquire with your medical provider about whether they're willing to, or whether they'll put it into your file. And then I'm going to move on to healthcare directives. Is there any other question about that? So related, and what sometimes gets confused are portable orders for life-sustaining treatments, POST forms. So these are different than a healthcare directive because this is actually a medical order signed by a medical provider that talks about, again, what kind of treatment you want, you do or don't want to receive in an emergency, life-threatening situation. This order is meant for emergency services providers. So if I have a heart attack in my home and the EMTs show up and somebody shows them my healthcare directive, they're not going to look at that. They're going to try to save my life. And so the only thing they would look at in that situation is this POST form. So if your common situation is, I'm 90 years old. If I have a heart attack in my home, I do not want the EMTs giving me CPR. I've made that decision. I've talked to my doctor about it. I just don't want it. If that's the way I'm going to go, that's good for me. So I want to have this signed that says I don't want CPR. My doctor signs it, and then I put it on my refrigerator so that in a situation where I do have an emergency and EMTs are called, they'll know. The emergency room medical providers will know. So we want to take the POST form with us, all of that stuff. So it's different from a healthcare directive. The healthcare directive is more sort of a longer term making decisions as you go, but the POST form is really for an emergency situation where decisions need to be made and a doctor needs to sign off on it. So we don't have, this is something I just say, go to your medical provider to get this form.
I just want to check in, see if there are any questions. Also, remember, folks can put them into the chat. So any questions about the difference between these two forms or?
Yeah, and I should say this is a new one that they just revised the form last year. So fully improved. They, in my opinion, have improved a few things and recognize that there are folks beyond just a physician who can sign this form. Okay, I'm going to move on. Just a couple of other tools, again, for getting help with decision making if you need it. End of Life Washington created this Living with Dementia Mental Health Directive. And I'm sorry, mental health is a bit of a misnomer, and there's a reason that phrase is included in this form. We acknowledge that dementia is not a mental health disability, but in order to get certain kinds of treatment, we had to include that word, or they had to include that word. So in any case, this is a great form if you have the time and patience to sit down with it. For anyone who has been diagnosed with dementia fairly recently or has concerns about dementia, it's really a form that's meant to walk you through different kinds of decisions you might have to make that are specific to somebody living with dementia. So for instance, what do you want to do about driving in the future? What are your preferences? How about relationships? A lot of times folks with dementia, when they move to, say, a nursing home, they might start up a romantic relationship with somebody there because this is a new, anyway, they don't remember that they're married or whatever the case may be. It causes lots of drama. So, really, these are hard decisions, but think through in that situation, what would you like to happen? What kind of care do you want? What kind of medicine? What environment would you like to receive care? Again, it's a lengthy form, so it can take some time. It doesn't have to all be completed. So if there's a decision you think, I really am not ready to deal with that, or it's not that important to me, you can always just cross it off. But it's great. I just think it's a really good tool. It's one of those things where you don't know what you don't know. So it does sort of acknowledge that here are some decisions you may need to, your caregivers may need to make on your behalf. So let's talk now about how you want those decisions to go down. So that's that. It looks like we have a question in the chat. Let's see. Okay, good. Thanks, Frank. Got a little, I'm keeping it clear, so that's excellent. The other form I want to mention is, as opposed to the Dementia Directive, which is specific to dementia, is a mental health care advance directive. I'm sorry, this is all like drafty looking. It's because they just changed the, recently changed a few things about the mental health advance directive law. So we're in the process of revising our form that's available on the website, the Washington Law Help website. So this form is meant to be for people with mental health disabilities to, again, help their supporters or decision makers make decisions on their behalf when they can't do it for themselves due to their mental health disability. So an example of this might be somebody with bipolar disorder who experiences periods of where they're manic and periods where they're depressed. And during those times, they're just not capable of making decisions for themselves or decisions that are in their best interest. And so in that situation, what kind of care do you want? What decisions would you like made on your behalf? So it's a great tool for folks who have a mental health disability to make some decisions before they're in a situation where they've decompensated and are not able to make decisions for themselves. Okay, so I'm going to move from the yes, mom has capacity to no, mom no longer has capacity. There's no power of attorney form or healthcare directive or anything that would allow someone to make decisions on mom's behalf, and she really needs a decision maker, a decision support. So we'll be talking about we'll talk about guardianship because that's the one that comes up a lot, but also alternatives to guardianship. And I should just say too, I get a lot of calls from folks who say, okay, so I need to file guardianship for my mom. And so in addition to the capacity question, which sometimes then leads to, oh, well, mom can sign a power of attorney. But if the answer is no, mom just can't sign legal documents, the other question I ask is, well, what decisions does she need to make that can't be made now? Or the other one that comes up is spouses call me and say, well, I need a guardianship because the nursing home said I need one. So that happens fairly frequently just because that's what nursing home folks might know is what a guardianship is, and this person needs a guardianship. In some cases, it's just not needed, and it's a lengthy process that we'll talk about. But so I do like to ask, why do you need the guardianship? What decisions need to be made that can't be made right now? And then we can talk about some alternatives to guardianship. So one option is having a representative payee appointed. And so for folks who are getting Social Security benefits or I think veterans benefits, and there are some other governmental benefits where someone can be appointed to manage your finances for you. So if let's use mom as the example. Let's say mom is not managing her finances, can't remember to pay her bills, just having a lot of trouble. The child, let's say, would then petition or apply to the Social Security Administration to be appointed as her representative payee. So the money would then come into a separate account managed by the child, who would then, adult child, would then manage, pay mom's bills and all of those things. So that's one alternative. If mom doesn't have the capacity to sign a financial power of attorney document, it's possible someone could be appointed as her representative payee. And I'm going to just read this question really quickly. So Kevin asked, do the two mental health directives go to the healthcare surrogate, and should they be named in the healthcare document? So I just want to make sure I understand. So answering the first question, if you've completed a dementia directive or a mental health directive, yes. And I didn't have the little slide that was like, where should these go? But yeah, that's a great question. And they should go to your healthcare decision maker. If you've appointed, for instance, a power of attorney, if you've completed a power of attorney for healthcare and appointed an agent, then those documents would also go to the agent. And then the question about should they be named in the document itself. So here's my concern, and I'm guessing if I'm answering this wrong, let me know. But let's say I've completed my healthcare power of attorney. I also did healthcare directive and a mental health directive. So I give those documents to my agent so they have everything. I personally wouldn't name my agent. Let's say my agent's my brother, Andy. I've named him my power of attorney. I wouldn't name him in my mental health directive or healthcare directive. And I think the only reason I say that is if I decide to change my healthcare directive, then let me go back. Let's say I have a falling out with my brother Andy and I want to name a new power of attorney, then I have to change all of my documents. So it's not necessary for your agent to be named in your healthcare directive and your mental health directive. So if you don't have to, I say don't do it just in case you need to change your power of attorney form. I hope that answered the question. Sorry if I went off on a tangent. You can let me know if follow up in the chat if that wasn't quite what you were getting at and you have an additional question. Representative payee, they're there to manage your finances if you get these Social Security benefits or veterans benefits or some other government benefits. And then another option for decision making, if someone doesn't have the capacity to make decisions for themselves and they don't have a power of attorney or guardianship, we have a consent to healthcare statute that lays out who can make healthcare decisions for you if you can't make them for yourself. And you'll see it's in a hierarchy. So starts with a guardian or a healthcare agent in a power of attorney form. But if you don't have either of those, it then walks through the list of optional decision makers. So spouse, domestic partner, children, parents, sibling, and just recently they added aunts and I think they added the nieces and nephews, aunts and uncles, and also the close friend. Which I actually think is great because there are some folks out there who are like, I don't have any of these family members who are still alive or, who are able or available to make decisions for me, but I do have my best friend who's my neighbor. And so the statute does allow that person. They have to fill out an affidavit that explains why they qualify as the close friend. But it just adds another person who can make some emergency healthcare decisions if needed, or whatever the case may be in a situation where somebody can't make decisions for themselves and need a support. I do want to mention, though, with the statute that where, as you're looking at the hierarchy, in these situations where you have more than one possible person, so like let's say you've got 3 kids, 3 adult children, they have to be unanimous in their decision making. So they won't just go to one kid and let the kid make the decision. They'll ask that all 3 agree on what the healthcare decision is, which, as you can imagine, might be problematic if you have people who don't agree. So it's not perfect, but it does give a few more options on who can make a healthcare decision if someone can't make a decision for themselves and they don't have a guardian or a power of attorney. And then let's talk about guardianship. And hold on, let me just double check. Okay, great. Oh, stepchildren. This is such a good, Joyce. This is a good question. Stepchildren. In my opinion, I'm just going to go back to the slide because I had this question once before, and we looked through the statute. It's not very clear, honestly, on whether stepchildren count as adult children. In my opinion, I think you can make the argument that stepchild should be included in the adult children category. But to be honest, it's not very clear from the statute, and you might have people who disagree, or importantly, a medical provider who would disagree. But I think in that situation, you would make the argument that this is my child and they get to make the decision. Or not, I guess, if you don't want them to. You could make the opposite argument. But yeah, that's where I would place stepchildren, but with just the caveat that, in my opinion, the statute isn't super clear on that point. Okay, I'm going to move on to guardianship. And just to be clear, guardianship is a court process. So if I have a family member who doesn't have capacity to make decisions for themselves, they do need some important healthcare decisions made, financial decisions made, and payee or consent to healthcare statute doesn't work. They don't have a power of attorney, and then I might have to turn to the court to ask to be appointed as their guardian to make decisions on their behalf. And just as a point of clarification, anyone can file a petition for guardian, not just the person who wants to be appointed guardian. And that includes the government. I certainly had cases where an elder who's in the hospital is determined they need care, but there's sort of no one to step up and file the petition for guardianship. So sometimes the Attorney General will do it. Usually it's after APS, Adult Protective Services is called. But just so you know, anyone can petition, anyone can be guardian with certain limitations. And the way it usually works is there's a petition for guardianship filed for somebody, then the court appoints someone who will investigate who should be whether a guardianship is needed, first question, and then who would be an appropriate guardian for that person. In the end, the court would make a decision as to whether or not a guardian should be appointed. So one thing to know is just this month, the guardianship laws changed, and Washington State's adopted this Uniform Guardianship Act, which has changed a lot of things and caused a lot of excitement among practitioners. So just so you're aware, if you have experience with guardianship, you might start to hear some different terms used and different processes. The concept remains the same, that the court appoints someone who will make decisions on behalf of someone who no longer has capacity to make decisions for themselves. But you'll start to see, so one of the things that changes, for instance, is we've changed our terminology. So guardian is now the person who's taking care of your healthcare. So it's guardian of the person. And we've adopted the term conservative for someone who will be making financial decisions on that person's behalf. So just a note to keep track of, the guardianship laws have changed. So we're going to be changing some things in the way we do things, but concept remains the same. I want to mention just a couple of other points of clarification. If the person for whom a guardianship is being sought, so the person that they're saying is incapacitated and needs help, wants to oppose the guardianship, they do have the right to appointed counsel. So similar to like criminal cases, they can request that the court appoint a lawyer for them because they can't afford one for themselves. And other thing I do like to point out, especially to family members who are seeking guardianship, it's not done when you get the guardianship completed. The initial petition and then letters of guardianship are administered. there are reporting requirements every few years. So folks just need to understand it's a big commitment. It's not the same as a power of attorney. It does require continued court monitoring of your actions. So just to keep in mind. I'm going to move on to talking a little bit about long-term care. We'll hit up long-term care. We're going to talk about what happens after death, and I might just zip through some of these slides because they're sort of heavy, but we'll make our way through. If you have questions, let me know, and I can stay a few minutes after if that becomes the case. As you can imagine, another thing to think about in planning ahead is for long-term care. The statistics are now that about 70% of people turning 65 now can expect to use some kind of long-term care. So that's care at a facility like a nursing home or assisted living or adult family home, or care in your home. Usually we talk about care. It's not just medical care, but it's assistance with what we call activities of daily living. So toileting, bathing, dressing, feeding, all of the things, making sure you remember your medications. So most people are going to need some form of long-term care. And most people are using Medicaid, which is a medical program from the state to pay for their long-term care, which is good in some respects, and in others very difficult because it comes with a lot of hoops you have to jump through. Most significantly, you don't qualify for Medicaid for long-term care if your non-exempt assets are above $2,000. It's not much money. It doesn't include things like your home, your car, certain kinds of retirement accounts, those types of things, but it's pretty limited, and a lot of people are in a situation where they have to spend their money, their savings on their long-term care before Medicaid starts up. There's some other concepts or other options. Veterans aid and attendance, if you're a veteran, they will add some additional funds for your long-term care. And then I'll talk a little bit about special needs trust. And the thing I don't have here is long-term care insurance. So it's still a relatively new product. I want to say 10 years, 10, 15 is when I started hearing more, it was about 10, about long-term care insurance. And it's pretty hit or miss, to be honest, from what I hear, as far as what it will cover, when it will cover. There have been reports of, requiring some strict waiting period that doesn't always work for folks. So it's not a perfect system. I think they're still working on it, but it has been an option for some folks. By and large, folks need Medicaid to cover their long-term care. And then I just want to mention a couple of, we're moving to the planning for the future, to the what happens after you die situation. So I want to just mention a couple of documents that I recommend for this sort of after death scenario. First, foremost is a disposition authorization. I'll show you what that looks like because they updated their form. So the People's Memorial has a great one. Disposition authorization form. So let me back up. So when you die, your power of attorney form ends. It's no longer in effect after you've died. So then there needs to be somebody who is allowed to make decisions about what happens to your body after you die. Generally speaking, the funeral director will take the direction of certain family members, and there's a hierarchy in the law. But if you would like to say who you want to manage your remains after you die and what you want to happen, I highly recommend a disposition authorization. And as I mentioned, People's Memorial updated it recently to acknowledge that we have new systems. So hydrolysis, alkaline hydrolysis, and cremation. Cremation's always been on there. Composting are listed here as options for what you would like to happen to your body after you die. So it's just a great form. Again, I think everybody should have one just in case. And it might be, if you prepay a burial plan, they may already have completed one of these documents with you, and it's part of that whole plan. But in lieu of that, if you just want to complete this form so that it's available, and yes, and again, give it to the person who you've appointed to make decisions for you, or let them know where it is. And then wills, most people know what a will is, so I'm not going to get into too much detail about it, but it allows you to say what you would like to happen to your stuff after you die. And there are other options in terms of, setting up a trust if you have money for a child or other heir. And one of the things I like about Washington law is it lets you create a list of personal property, not like home or real estate, but just the things that you have and where you would like them to go. So if you have some very specific bequests you would like to make to specific people, you can create a list, and it becomes part of your will. The nice thing about it is you have your will, but then you also have the separate list that you can keep changing as you need to. Just make sure you destroy the old one and put the date at the top of the new one. So it's flexible in that way, and I appreciate that. Just again, trust is a whole other heavy area of the law, but and for most people don't need trust. Washington state is actually not a bad state to do a probate, the process that you go through after your heirs would go through after death. But one of the places where I see trust as being helpful is if somebody is on Medicaid benefits or SSI or other benefits that would be impacted by a lump sum of money or an inheritance. And in those situations, the money can be placed in a special needs trust. So these are special trusts that say the money won't be used for food and shelter and things that are paid for by the person's benefits, but the money is available for other things that they need, like their clothes or special equipment or a new bed or all the things somebody might need that wouldn't be covered by their benefits. So they're great vehicles, and I can certainly answer more questions about them along the way, but I just want to mention they're an option. Any of these trusts can be set up by, say, a family member or somebody else, or they can be what are called self-settled trusts. So I've worked with a couple of clients who were on SSI and Medicaid benefits, which are restricted in the amount of money you can have, as I mentioned before. And they got a personal injury settlement of $100,000. And it would throw them off their benefits and create a lot of drama. So we worked together to help them set up a trust that would hold that money so that it could last into the future for the things that they need, but also they could get their medical benefits and get their medical care. And then just quickly, probate, in case you don't know, is a court process that happens after someone dies. And it's just the process of appointing a personal representative who will manage your stuff and make sure that if you have a will, your wishes are honored, or distributes the property and sells, real property, all that stuff. It's not necessary in every case. It's really only necessary where there are assets that need to be probated. So it's not something everybody does, and there are a lot of alternatives to probate. So if you have an estate worth less than $100,000, you probably don't need probate, and there's a separate process that just requires signing affidavits. There are other options like community property agreements. So it's usually a case where somebody has assets that need to be distributed that can't be done without a probate. And just so you all know the different terms I've listed here, testate means you died with a will, intestate means there was no will, community property, Washington community property estate. So anything that the married couple owns is owned as a community. And then I threw this in just because it's kind of fun, but it's the question of, I've died, I didn't have a will, where does my stuff go? And it's like this little puzzle, like if I had kids but no spouse, it goes to the kids, and it's, you know, it's like a logic puzzle. Anyway, I just threw this in there in case you're ever curious about, you know, what happens if I don't have a will and I die, or I have a loved one who's just died and we need to understand where their things will go. And let me just check this question real quickly. Okay. Michelle says, can a special needs trust be set up during a person's life in case their probability of long-term care is very high and the family will not be eligible for Medicaid and not be able to afford to pay out of pocket, thus enabling Medicaid eligibility and protecting the rest of the family? Yes, and it all, it's going to depend a lot on the situation. So I'll just give a couple of examples and hopefully this will help. So if I have a developmentally disabled child, I might want to set up, and I have, you know, enough money, I might want to set up a special needs trust for that child for when they turn 18, so that they will have access to the money, but they can also get their medical benefits. One caution I have about setting up a special needs trust if you don't currently have benefits is the special needs trust is restricted. So it's not the trust, there's a trustee who will manage it, and it's not supposed to pay for food and shelter. So if your only source of money is the money that's in the special needs trust, it won't pay for your food and shelter. So you're kind of, I think about this because I had a client once who didn't have income from a job or any place else. The only income he had was this lump sum of money his mother left him. And he wouldn't be eligible for benefits. So if he put all that money in the special needs trust, he wouldn't be able to pay his rent each month because he didn't have any other source of income. So that's just the caution. It is possible to set up a special needs trust before you start getting benefits, but it's usually a situation where that person already has income that will pay for their food and shelter and all the things that they need. I hope that was clear as mud. Sorry. They're so complicated, Jess. It's taken me a long time, and I still have to call private attorneys to get their advice on each new scenario. So Vicki asked, if a married couple owns a home and one person dies, does the home go into probate or does it go to the surviving spouse if there's no will? Oh, great question. I've been dealing with this a lot lately. So our law says if a married couple owns a home, then and one dies, the home automatically goes to the other. Unless, let me just like throw out the caveat, which is you may have a deed that treats it separately, you have to deal with that. But generally speaking, our law says if one spouse dies, the home automatically goes to the other spouse. The problem then becomes if my spouse is dead and I want to sell the home, his name is still on the title to the home. I'm going to run into trouble with that. So probate is a possibility. That's one possibility. I can go to probate, get a personal representative, or be appointed a personal representative and just transfer the home into my name alone. Another cheaper, less complicated option is what's called a lack of probate affidavit. And I'll share this with Tracy just so you have it, but it really is just a document that says, the law says the home is mine. And then I fill it all out and I take it to the recorder's office and record that document. And the reason it's come up for me quite a bit recently is I've had a few spouses call and say, my spouse, and I'm sorry, we're going over here. Tracy, are we okay? Okay, I won't be, I'm almost done with my presentation, but I want to mention this too, just in case this ever comes up for y'all. I've had a couple of cases recently where one spouse dies and that spouse was getting Medicaid for long-term care. And in that situation, DSHS will then put a lien on the home to try to collect the money that they paid to provide long-term care to the deceased spouse. And in a lot of cases, they could collect eventually, usually when the home sells or it's transferred or something like that. But if there's a spouse living there, the spouse can file one of these lack of probate affidavits, record one of these lack of probate affidavits, and then contact the SHS, and they'll release the lien, they'll lift the lien. So that's just something, again, this is not Vicki's original question. It's just something to keep in mind. If you encounter a scenario where there's a lien on a home due to estate recovery because somebody received Medicaid during their lifetime, there are ways, depending on who's still living there, to deal with it. But yes, anyway, back to Vicki's original question, which is probate's one option for dealing with the home. Another is this separate lack of probate affidavit. And
I've advertised a couple times. I've seen that there's this sort of free will option where people can, download some different forms and kind of fill it out. Is that something you would recommend if you have a fairly simple estate, or would you recommend just paying the money to go to an attorney to talk things through?
And you sort of indicated this. It just depends on how complicated your estate is. The more complicated, the more likely I'm going to tell somebody you should go to a private attorney and just spend the money to have them set it up. If you don't have a very complicated estate, it's pretty simple. One, there might be a legal clinic near you that is doing wills preparation. I know we do. Quite a few other counties around the state have volunteer lawyer programs where they're preparing wills. So that's something to look into. And then, there's, and I'll share this with you. There's one I know of, it's Washington Wills, and they have a pretty straightforward, simple will that, again, it's really just a matter of saying who your heirs are, who you want things to go to. But if you need something more complicated because you do have a complicated estate, then it's it's worth talking to a lawyer about it.
And the other question that popped into my mind is, Washington is not a common law state. Like, you can live with somebody for 25 years, never get married, and you're not considered the legal spouse. Like, in a case like that, you would really want to have a will, it seems like.
Yeah, that's a really good point. Yes. And actually, one of my colleagues had this situation. There are, just as a side note, there are ways to assert that you have a committed intimate relationship or had a committed intimate relationship and are therefore entitled to 50% of the community property or wherever the community property might be. That's just more complicated. So they've allowed for that in the law. However, it is, as you mentioned, especially in a situation where you are unmarried and you do want your assets to go to your partner, having a will is a great way to do it. Because as you saw in that chart before, it really just if somebody dies without a will, it comes down to they're looking at family members. So if you aren't a registered domestic partner, if you aren't a spouse, then it does make a lot of sense. And just the last few slides here are just where to find resources. So I mentioned Washington Law Help, where you can find those free power of attorney forms and healthcare directives. And then I definitely, that's what the website looks like. There's a special section for seniors. So that's where we put our power of attorney forms and healthcare directives. Memory loss info WA is a section of the Community Living Connections website. And that has a lot of great information for folks who are living with dementias, with Alzheimer's, dementia, memory loss. There are a couple of publications, including the Dementia Roadmap for caregivers and the Dementia Legal Planning Toolkit. It's a good resource for folks who still have the capacity to sign legal documents and start that planning process, and just walk through a lot of things we've talked about today, which would help somebody. And then I really love the End of Life Washington website in terms of their resources. They have a lot of great, videos and forms and all of that. And I mentioned People's Memorial for that. The Disposition of Remains form or authorization. They have a lot of other really great resources on People's Memorial as well for that planning piece. And then that's it. I think I zipped through, but I hope it was all very clear, and I'm sorry to go over time.
Hey, you covered a lot of ground, Meredith. Thank you so much. It's really, really, really well done. And I just want to put in a reminder to everyone that we are going to be having People's Memorial do a program in April, so you can learn more about different options for the disposition of your physical being. And yeah, we'll be kind of throughout this year trying to give more and more information so everybody can make these conscious decisions about what you want to put into these forms. So knowledge is power. You're on mute. Anyway, any last questions from anybody? You'll have to come off of mute. Okay, I don't see anything else in the chat. Meredith, thank you so much for your work there at the Northwest Justice Project. Thank you for this presentation. Again, I will be sharing the slideshow. And
right there.
Oh, here's one.
Oh yeah.
Oh yeah.
Yeah, if you have more questions, my contact information is on that first slide. So Tracy will share that with you. And yes, feel free to reach out if you have any remaining questions or something comes up.
Great.
Okay.
That was
Well,
the
thank you
question
so
that we
much.
wanted answered.
Yeah, okay, good. Well, yes, yeah, please feel free to reach out. I'm so grateful
Yes,
you
she
have me
didn't answer.
today. Thank you.
But at least we got the question.
Okay, was that a last
There
question?
it
I
goes.
couldn't tell. I'm hearing. Kevin, do you have a question? Okay. All right. I guess that's it, everybody. Have a wonderful day.
Bye. Thank you.
Yeah, thanks so much.